2 hours later.
And this is Jennifer Johnson. I think we've got it figured out.
Okay.
Okay. Are you prepared to write something down? I've got an 888 number you need to call in with a meeting code.
Yeah, hold on just a second.
Okay.
Okay, go ahead.
Okay. The phone number to call in is 1-888.
Okay.
238. 5279.
5279.
Yep. And then you have a meeting code.
Okay.
And that is, it's a lot of numbers, so bear with me.
Okay.
969.
969.
140.
140.
552.
552.
124.
124.
78.
78.
And then you have a PIN.
Okay.
The PIN is 8888.
8888.
And then after you do the PIN, you hit the pound sign.
Okay, I got you.
Okay, we're ready for you to call in then.
All right, I'm gonna call now.
Okay, thanks. Bye.
Enter the meeting ID followed by the pound sign. Thank you. Please hold. Thank you for attending the meeting. Enter the meeting PIN followed by the pound sign.
Oh, he's here.
You guys there?
Hello?
Yeah.
Yep, we're here.
Are you there, Mr. Hill?
Huh?
Mr. Hill, can you hear the cord?
Yes, I can hear it.
Okay. Court recorder, I have a tape recorder. Let me get the tape recorder going, okay?
Okay, can I go ahead and tell you guys that this call is going to be recorded and that I need your consent?
Yes. Yes, I'm required to record our hearings.
Okay.
That's how we get, in case you decide to appeal or on behalf of the agency decides to appeal, that's how we make what's called a record. That's how you're able to get from here to this recorded if either party desires to do that. Does that make sense?
Yes, sir.
Okay.
Can I go ahead and say for the record that I'm here on special appearance?
Yes, in just a minute, let me get the tape recorder going.
Okay.
Okay? All righty. Testing 1, 2, 3. This is Monday, June 1st, 2020. A child support hearing for the Oklahoma Child. My name is Barry G. Stafford. I'm an administrative law judge with the Oklahoma Department of Human Services. I've been appointed to conduct this hearing at this office today. The next, or this case coming on for hearing, was that case is State of Oklahoma, a Federal Department of Human Services, Oklahoma Child Support Services Office versus Hyman. Is that correct? Hyman, T-Y-N-A-N?
Yes.
Is Hyman how you pronounce your first name?
My first name is spelled with a capital T, and it's spelled with lowercase y-n-a-n, and it's pronounced Tynan.
Fine, okay. The Office of Administrative Hearing is 2011-07341. The department, same with group number. Ms. Johnson, I'm getting a little squealing. I think if you move the microphone just away from the Can you hear the report okay?
I heard that just a little bit.
You can find it.
I don't know whether that was, anyway, the department's family group number or child support number is 693254001. Okay, the custodial parent is shown to be Charlotte Stokely, and was she notified to be present at this hearing, Ms. Johnson?
We didn't need her to be present today, Judge.
Okay. And then Mr. Deal is present by telephone. Is that correct, Mr. Deal?
Yes, I was wanting to state for the record that I'm here on a special appearance for the motion to dismiss in pursuant to Title 42 U.S.C. 1301D and the 14th Amendment of Section 1.
Okay, just a minute. Let me also for the record indicate that the state and multi-child court office is appearing through Assistant District Attorney Jennifer Johnson. And Ms. Johnson, you're present here at the Oklahoma office, correct?
Yes.
Okay. And Ms. Johnson, I don't see any other staff or anyone else in the hearing room.
If needed, I'm going to bring him in to testify, but he's not sitting here with me right now.
Okay. Mr. Dill, if you will, would you raise your right hand and let the court administer an oath, please?
Yes.
Okay. And we'll go for, I'll let you speak in just a minute. But I do have to administer an oath.
Okay.
For an affirmation. Okay. Do you have your right hand raised?
Yes, sir.
Okay. Do you solemnly swear or affirm that any testimony that you may give at this hearing will be the truth, whole truth, nothing but the truth?
Yes, sir, I do.
Okay. Let the record show Mr. Bill can do his work or affirm. Ms. Johnson, should you call Ms. Pringle or someone else, just remind me that they have not been sworn in at all.
I'll do that.
Great. That's fine. All right.
Okay.
Before I let Ms. Johnson still speaking more, I did get some documents, and the only purpose I'm going through right now is just to make sure I have whatever document either Mr. Bill or Ms. Johnson have sent to the administrative court.
Okay.
So, now these have not been marked at this time as Exhibit A or B or Exhibit 1, so I'll just identify a document. So we got fairly lengthy, this was a document, I believe this was submitted to, shows the introduction, Jennifer Johnson, and to whom this may concern, I guess, some email, or anyway, documents provided by Mr. Deal. And because of the press of time and the technical problems we've had this morning, and I'm not sure at this point if it's even appropriate that I read it beforehand. So I just want to say the court has not read this, and I have not actually counted all the number of pages.
Judge, I just looked at the number. Yeah, there's 24 pages, and that was submitted by Mr. Dill.
Okay. So, and again, I'm just trying to identify it. They haven't been offered for into evidence yet or anything. So, in the Johnson, I'm looking at you, but you understand I'm speaking to Mr. Dill as well.
Yes. Yes.
The next document is an administrative order. let's see, this has been admitted. This has been filed. It's an executed administrative order. It was dated September 10th, 2012. Filed and it was an enforcement and notice of intent to revoke or suspend license and a notice and order of child support lien. Just to indicate, this one had a, let's see if there was a judgment entered on this one.
Yes, there was.
Okay. Child support was to continue at $249 a month. It identified the child as J-Ron, I guess, born June 15th, 2010. He's about to have a birthday.
Yes, sir.
Let's see. Oh, he's just going to be 10. Okay. And then there's a judgment was entered. Let's see. Approved interest was reduced to judgment for $1,494. And there was a balance on a prior judgment of $5,229. Anyway, I'm just identifying the document and giving everybody and make sure we're on the same page. So that document came to us, and then there's out of the District Court of Mulkey County. Well, there was 2 pages, but one is blank, so I'm going to discard the blank page. So I guess it's just a 1-page document signed by a judge of the Mulkey District Court. Let me see what date this was there. November 7th, 2017. So anyway, there's that document. And then there's an order determining parentage and child support obligation, which of course is a multi-page document, including a guideline. Both parties were present. Looks like that was by agreement. Is that correct, Ms. Johnson?
Yes.
Okay. So paternity of the child was by agreement, and child support was at that time, according to this document, the amount of, I think, $249 per month, looks like, and was there a judgment taken in that one? I think so.
Yes, there was.
For $5,796.30. So anyway, there's that document. Now I got another document or two. Then there's an order that was entered out of Mulkey County District Court on October 6, 2015, and on 15th, and it has guidelines attached. It's a 2-page. It looks like it's 4 numbers.
No, it's multiple pages, and it shouldn't have guidelines. It should have a record of payment attached.
Yeah, that order is 4 number pages plus a record of payment, which is 3 pages. And that shows a total due and owing then of $17,373.19. Okay. And then, so there's that document. And then there's a record of payment. Let's see how to identify this.
And does that be the current record of payment?
Current record of payment, yes. Which shows the balance, principal and interest of $31,362.45. Those are all the documents. Again, Mr. Bill, I'm just trying to identify documents that either you have provided to Ms. Johnson to send to the court, or Ms. Johnson on behalf of the state have sent to the court. Ms. Johnson, does that sound like all of the documents that your office has transmitted to the administrative court?
Yes, sir.
Okay. So, I'm going to let Mr. Dill, you'll be given an opportunity to make a statement in just a minute.
Okay.
I'm going to let Ms. Johnson, on behalf of the agency, make what we call an opening statement.
Okay.
Now, let me tell you, an opening statement is not testimony. It's simply to let you and the court know what Ms. Johnson believes the issue or issues for this court to decide today. And Mr. Dill, this is a court of very limited jurisdiction.
Okay.
We just deal with financial issues regarding child support. And so that's it. I usually say another thought or two, but Ms. Johnson and Mr. Dill, I've been away from this office for 2.5 months, and I'm a little rusty.
That's all right. I hear you.
I apologize. I think we're all kind of groggy from sheltering in place, and we all kind of are still sheltering in place. Okay, so, well, we'll just go ahead. So I've given him that this is not evidence, and I'll be giving Mr. Dill an opportunity to say something. So I'll let Ms. Johnson speak, and then Mr. Dill, I will let you speak, okay?
Okay.
Okay. So Ms. Johnson, you have the floor.
Thanks. Well, Judge, Mr. Dill is a requesting party in this matter, so he would have the burden of proof to show why the tax intercept should not be garnished. So I will give a brief synopsis of where we're at and why we're here today. As I think what I have prepared for my evidence to show is that in 2012, Mr. Dill was ordered to pay child support in this matter. Child support was set in the amount of $249. And in addition, and also in 2012, a judgment was taken against Mr. Dill for $5,229. Since that time, Mr. Dill has not paid regularly. We've had a few instances throughout the time frame where he did start making some payments, but they've not been regular. So, and I also want to mention that when that paternity order was first taken, Mr. Dill was present and he signed that order. That order was not by default. The next order that we had was notice of enforcement, notice of intent to revoke. That was in September of 2012. That order was by default, and that order took an additional judgment of $1,494. In addition, the total amount of the prior judgment was still due and owing. Mr. Dill continues to not pay regularly. Therefore, in October of 2015, a contempt was filed against Mr. Dill, and in the purge order, Mr. Dill was present. He also had an attorney present, and another judgment was taken against Mr. Dill for $7,806.44. All the judgment at this point is owed to the state, which is why I didn't notice the custodian for this hearing, because it's not owed to her. The current record of payment shows balance of $31,362.45. That was the reason behind the tax intercept, and whenever the tax intercept went through, Mr. Dill contacted my office, and we ended up setting this hearing so that we could have the court determine whether or not to continue with the tax intercept. And that's all I have as an opening, just to summarize that for the court.
Okay, Mr. Dill, do you have anything in the way of an opening statement?
Yes, I would want to know, is this a criminal action or a civil action?
This is a civil action.
Can you let the record reflect that this is a civil action?
It is.
Since this is a civil action, I'm making a notice to dismiss for lack of sworn complaint by an injured party, and no injured party is present.
The injured party is the state of Oklahoma. They provided funds to support your child.
Well, then the injured party should be the child, but the child is not on the notice.
Okay. I'm not sure. The child does not have to be given notice. The child is a minor, correct?
Yes.
Supposed to be 10 this month.
Well, what about the custodial parent? The custodial parent's not listed on the notice either.
Well, Ms. Johnson indicated that all the monies are due to the state in this case.
Okay.
And they're usually, I mean, now, there's still current support due and owing, correct, Ms. Johnson?
Yes, that's correct.
But as far as tax support, and now this is, Ms. Johnson indicated that there's been some tax refund. Have you had a tax refund that's been intercepted, Mr. Dill?
Yes, sir.
Okay. Now, do you know how much?
Huh? Oh, yeah.
What amount?
The notice said that the past due amount was $37,000.79.
No, but that's right. But how much was the tax refund?
Oh, the tax refund, I believe it was for $1,700, and state took $200 of that, and then the rest of it went to federal.
Okay. And you object to the state getting $200 out of that money?
Yes, sir. And I also want
to even pay one. How much is your current child support? Is it still at $249?
Yes.
I'll ask Ms. Johnson. Okay.
Yes, it is. It has not been modified.
Okay. And Mr. Deal, you may need to understand, I don't know for a fact at this point that the state may be expending more than $249 monthly to support your child.
Mm-hmm.
In either event, they may be spending more, but in either event, your obligation is $249 per month to support the child.
Right. Now, can I go ahead and say for the record too, that I'm appearing as my natural person and not the artificial person?
Okay.
Now, another thing that I wanted to point out is that
now, Mr. Hill, this is just simply to make sure we know what the issue is, and I think we all agree you got a tax refund for $1,700, $200 came back to the state of Oklahoma, and that's what you object to. The state to have those $200. Is that accurate?
Yes, that's what I'm objecting to.
Okay. So would you agree that that's the issue we have before the court?
I don't agree that the state is the injured party.
Okay. Like I've already mentioned, I do believe the state is the injured party since the state is in. Now, I don't know that there's any. I'm not sure how Ms. Johnson is going to show that.
Right.
I mean, there's been no evidence introduced at this point in time. Her statement says that the state is expending funds to support your child.
Right.
And these funds are due to the state. Okay?
Yes, sir.
Okay.
Will I have a chance to keep, okay, go ahead, I'm sorry.
Yeah, let me ask Ms. Johnson. So, Ms. Johnson, I know there's been a lot of documents here, but they haven't been admitted as evidence at this point. Do you want to, I understand this, Mr. Well, it's his burden, I get that, but I guess the state needs to, since there's not a custodial parent here, show some evidence that the state has been expending funds in it, whatever. Now, some of these, that PO's amount of money, so are you going to have that through the Frankel, or are there some?
Yes, I can have.
Through that. Now, I can take judicial notice of any administrative or district court orders.
Yes, I was going to request that anyway, so.
Okay.
I guess we could go ahead and get that part out of the way, and I'll request that you take judicial notice of any court orders that are filed with the administrative court and the district court of Oklahoma County.
Okay. So, Mr. Deal,
yeah.
there's been an administrative or district court order that has not, that has become a final order that's not on appeal, and so far, I've been furnished nothing to indicate there's any formal appeal within the appellate court in Oklahoma. So I'm going to take judicial notice, and that also means that for the last order that determined any judgment, I actually, as a court, cannot go back beyond that last court order. In other words, if you were coming in and saying, well, there's a judgment entered in, say, when the paternity was determined in 2012, I believe. If you now disagree with, apparently that was by agreement with you and with the custodian parent. If you now today were saying, well, but I really didn't know that judgment, I made some payments to her, etc. I can't entertain those arguments today now.
Right, I hear you.
So I can only go back to the last district or administrative court order as far as how much was owed at that time. Now, coming forward, if you said, well, for example, on this latest record of payments, again, not admitted into evidence yet, but let's say that they've got you not paying anything December 2019, January, February 2020, they just showed no payments were made. If you came in and said, well, I made $1,000 payment in one of those months, then yes, I can listen to that. Now, a federal tax refund offset, and Ms. Johnson, I'm starting to get into that a little bit, but in the law, man, it's been a few months. I think the minimum requirement is a balance of $500. Is that?
Well, Judge, if there are state benefits being expended, it's $150.
$150, that's true. Okay. So, Mr. Deal, the state, if you only owed $100, then the state couldn't, and they intercepted any of that, I guess you would prevail in that regard. But the allegation is that you owe over $30,000 principal and interest, so well above $150. And and we're not talking about anything else on enforcement today, are we, Ms. Johnson? Just simply...
No, just a tax intercept.
Right. We're talking about the debt here, right?
Would you
Right.
agree with Mr. Dill in his statement. He thought that the state had intercepted or received $200. Do you have any idea if that's accurate?
It's been more than that. I can have Ms. Kriegel testify to the amount, but it's let's see, we received a stimulus, I believe, and then we received $754.44 from federal and $168.56 from state, and then the stimulus was $1,049, and that's split between two cases. We're not the only child support case.
Okay. And Mr. Dill, all of that will go to help pay what you owe on this debt.
Well, but I know that according to the state of Oklahoma, and it's not really benefiting my child. But can I speak more about the debt?
Well, just a minute. So, let me indicate that I'll take judicial notice of the order of District Court of Oklahoma County of October 6, 2015.
Okay.
I'll take judicial notice of administrative court order, isn't it? Determining parentage and child support.
Yes, the original order is administrative, yes.
And it was filed in district court in Oklahoma County on March 7, 2012. So the court will take judicial notice of that. The court will take judicial notice of a one-page document, consent document, District Court of Oklahoma County that was dated November 7, 2017. And filed that same day in the District Court of Oklahoma County. And then an administrative order enforcement on September 10th, 2012. So the administrative court will take judicial notice of all that. That means, Mr. Dill, that they don't have to have a witness as far as offering into evidence. Those will be admitted into evidence.
Are you including the order?
We probably ought to mark these real quickly as whether they're the state one to.
If I could get to them chronologically.
Okay.
Yeah, if I could order those. I'll get to those chronologically if I could. That'd be the easiest for me to maintain what's what. I'm going to mark the order determining parentage dated February 6, 2012 as Exhibit 1. State's Exhibit 1.
All righty, let me do that. Has Mr. Dill been furnished at some time with copies of all these? Yes. Okay. All right.
Then I've got the administrative order dated September 10th, 2012 as State's Exhibit 2.
On that, I got a proof that it's submitted on. Okay. And then, I think I've got it. Okay. And then, I'm sorry, what's the next one?
The administrative order dated September 10th, 2012.
Okay.
And then the next one is the district court order. Oh, sorry.
I'm sorry, I'm a little slow here. Okay, and then the next one's the district court order.
Yep, dated October 6, 2015.
Okay.
State Exhibit 3.
And the one-page district court order?
Yes, State Exhibit 4. And that's all of the court orders.
Okay. Okay. So this concludes the opening statement. Now, because did you want to call Ms. Sprinkle, or how did you want
Do you want me to do that first, just as a procedural matter? Okay.
I think you've got to establish that the death.
Right.
And then.
Okay, I've let her know it's time for her to come in.
Okay. Do you need me to pause off the record, or?
No, she'll be right in. Her office is just right next door.
Okay.
I think I hear her now.
Okay. I thought she was quite a ways away from the conference room, or maybe your office.
Her office is right next door, and mine's on the other side of that.
Okay.
Don't forget to swear her in.
Okay.
If I sit over here, you can't see me. I can move the camera if I need to.
There we go. Okay.
All right.
Let the record reflect that Ms. Johnson, on behalf of the state, has called Ms. Kim Pringle to the stand. Ms. Pringle, let me ask you if you'll raise your right hand. And Steve, let me swear you in. Do you solemnly swear or affirm that any testimony you will give at this hearing will be the truth, whole truth, nothing but the truth?
Yes, sir.
Okay. Let the record reflect Ms. Pringle has just so forth. And you might ask her for her name for the record and spelling, and then we'll have that.
I will. Thank you.
Sorry.
The meeting has been automatically ended.
Can you state your name for the record, please? Kim Pringle. Can you spell your last name, please?
Priegel.
And what is your position?
I'm the office manager.
How long have you held that position?
For about 15 years,
How long have you worked for child support services?
27 plus.
And as the office manager for child support services, are you the custodian of our records?
Yes, ma'am.
And are you familiar with time and bill case?
Yes, ma'am.
As a custodian of our records, are you familiar with the record of payment or time and bill?
Yes.
And can you state to the court the balance on that record of payment?
$24,546.23 principal, $6,816.22 interest, for a total of $31,362.45.
Are you the supervisor for our office?
Yes, ma'am.
As a supervisor, do you supervise all of the caseworkers who would have updated and prepared his record of payment?
Yes.
Does all offer, as stated Exhibit 5, the record of payment for time and bill?
Okay. Mr. Neal?
Yes.
Do you have any objection to the record of payment?
Yes, sir, I do.
Okay. I'll just note your objection. Okay?
Okay.
I'm going to overrule your objection and this takes Exhibit 5. So, do you want to state a reason, though, Mr. Dill, for objecting to this document?
Yes, sir, I do.
Okay.
The payment of record is a voluntary offer, and this is not acceptance of the offer, and it is not express agreement. Besides this not being what I requested, it does not show participation in the program. It shows that I had to make the payment as a necessity. It was a necessity because I was being coerced and threatened with contempt and jail time to pay a debt, not even to the state, but to a private collection agency. These payments are under duress and not by free will. These payments were taken from me by fraud and theft and extortion.
Okay. I think that's sufficient. That's your objection.
Okay.
As the court indicated, I'll overrule it and, okay, Ms. Pringle, the court has a brief question. Does the record of payments include any recent payments, either made voluntarily by Mr. Deal or through any tax refund intercept, or by any other party on paying on this account?
Yes.
Okay. Can you indicate if you know?
Yes. In March of 20, we collected a total of $864 from his federal taxes, and it was split. He also has another case in Tulsa County. That amount was split between two cases. $754.44 applied to Mulgie's case, and $109.56 applied to the Tulsa case. Then on 5/6 of 20, we got the stimulus check for $1,200, and it split between the two cases. $1,049.85 went to the Mulgie case, and $150.15 went to the Tulsa case. We are also holding the state taxes of $168.56 that have not posted to either case because of this hearing today.
Okay.
It will be posted between.
Okay, that's fine. Mr. Deal, do you have any questions of Ms. Pringle?
No, sir.
Okay. Ms. Johnson, did you have any?
I do have a few more questions for Ms. Pringle. Ms. Pringle, is the state of Oklahoma expending funds to support the child at this moment?
Yes, ma'am. The mother is currently on TANF. I do not have those dollar amounts.
Do you know how long the mother has been on TANF?
Since September of 10, all the time. She's never gone off.
So she's been on TANF for the entire time that our case has been open?
At least since the order. I'm not sure when the first date of the first order was.
And do you know if all of the money that is owed at this time is owed to the state?
Yes, ma'am.
It is?
Mm-hmm.
I don't have any further questions for Ms. Pringle, Judge.
Okay. All right. Do you want to call Mr. Dill as your witness, or do you want him to proceed?
I'll let him proceed.
Okay. Mr. Dill?
Yes.
Judge, so can we excuse Ms. Pringle?
Yes. Okay. Mr. Dill, I'm excusing Ms. Pringle since you didn't have any questions of her. Thank you. Okay. Pringle has exited the conference room. Okay, Mr. Dill, your opportunity to present evidence or testify as to why the court should not enter an order confirming the tax refund intercept.
Okay. The past due arrears debt is a lien is against my issue SSN, correct?
Sorry? What?
The past due debt that said that I owe is a lien that is against my issued SSN, which is my social security number. Is that correct?
No, Ms. Johnson, did you want to reply to that?
It's not a lien, Judge. It's a court-ordered debt.
Yeah.
The debt itself is a lien that's against the social security number.
No. Can you?
That's what it says in the child support.
Really?
That's what it says in the child support handbook.
Hey, Mr. Dill, it's only that or evidence that the court is interested in and whether you have paid a sufficient amount that you owe less than $150.
I thought this hearing was to challenge if I'm the person who owes this debt or not.
Well, that's true. I don't think that, you're not the person that owes the debt?
No, because the lien
The father of this child, I
is
thought you were,
the piece of personal property that the lien is against is not my property.
well, it's not a matter about a property debt or a lien on property. At this point, I'm not saying you can't be a lien on property, or it doesn't result in a lien on property, but it's just,
if we're talking in regard
$249,
uh-huh.
you were lawfully ordered to pay $249,
Uh-huh.
an administrative or district court for the support of your son. The department has kept record. Payments were to be made through the child support office, the Oklahoma Beach Child Support Office, and they allege that you owe a little over $30,000.
Right.
And for federal and state tax refunds.
Right.
At least for federal, I'm not sure. Is the state thing at $150?
Now,
I thought the state was at $50.
Now,
Anyway,
if this is returns to a debt, the debt itself, like this whole hearing, the debt is a lien that's against the Social Security number, and I do not own that Social Security number, and I don't own that Social Security card.
you don't have a Social Security number?
I have a Social Security number, but it is issued to me by the Social Security Administration, and the Social Security Administration, they own that number and they own that card. It's printed on the back of it's printed on the back of every Social Security card.
Okay, well, this isn't Social Security, this is just...
Right, but we're talking in terms of a debt.
Tax refund.
But we're talking in terms of the debt that you guys are saying that I owe. So therefore, child support has the burden of proof to prove that I owe this debt. Well, that debt is a lien that's against my issued Social Security number that I do not own. In order to put a lien on something, you have to put a lien on somebody's personal property. That's not my personal property because I don't own it.
Well, let me ask this, Mr. Dill. Have you paid your child support?
No, sir, because... No, sir, because whenever I signed that agreement, it was because it was under coerce and duress, because they were threatening me that I would be punished by law. Therefore, consent and free will is an essential element of a valid contract. If I didn't sign those by free will and by consent, then that agreement is invalid.
Well, this is
Mr. Dill, are you talking about the original paternity order
I'm talking about...
from 2012?
I'm talking about the paternity acknowledgement that was the offer, and I'm talking about the offer for child support services after paternity was established. Those are voluntary offers. Those were given to me in the impression that I had to do that this was a court order and that child support was of the state. Child support is not of the state. You guys are a single and separate unit, not of the state. The Central Support Registry is operated and owned by a private company that is contracted through Oklahoma DHS and Child Support, and their name is System and Methods Incorporated. And the Office of Oklahoma Management and the Office of Oklahoma of Enterprises and Management Services, they manage that contract from the private corporation to the Oklahoma Department of Human Services Child Support Division. They manage that contract, and and in my documents that I gave you the RFP that proves that allegation.
Are you wanting to have these documents that Ms. Johnson's office forwarded to the court submitted for evidence?
Yes, sir. Because this is a fraudulent case. This is a fraudulent case.
Under the judge, think a lot of the documents are beyond the scope of this hearing and you would.
No, they had everything to do with this debt. Objection. They had everything to do with this debt. Everything that I'm mentioning right now has everything to do with this debt.
I further object that it's an improper narrative.
Well, I'll note your objection and overrule it as it's documents for the record.
Okay.
For whatever they may be.
Okay.
Whatever values they may be. So, can you summarize? You have to summarize what your objection is. In other words, what you just stated, you believe is summarized by these documents that you've submitted. Is that correct?
That's correct, and I'm also stating that the debt comes from a lien that is against personal property that is not mine. I cannot be held responsible for a debt if the lien is against property that is not mine.
Okay. Are you saying you do not? Well, I don't know. I'll let Ms. Johnson, did you have any questions, Mr. Bill?
I'll ask a few to maybe just sort of grasp a little bit of what's going on. So, hey, Mr. Dill, are you the father of Jaron D. Dill?
I am.
Okay, and his date of birth is 6/15/2010, is that correct?
Yes, ma'am.
Okay. And is your social security number 445966848?
That is my issued number, and I do not own it.
Okay. Okay, but that is your issued social security number for you?
That's right.
Okay. And do you live at 6312 East Virgin Street in Tulsa?
That's where I stay.
Okay. And are you, just so we can be clear for the record, are you objecting to the tax intercept on both the state and the federal taxes?
Yes, and the stimulus check.
Okay. So all three of those. Okay.
Mm-hmm.
And whenever, on February 6, 2012, when the order determining parentage was filed, were you present on that date?
Yes, I was. I was at the child support office that day, and
Okay. Okay. And did you sign that order?
I did, but she gave me the impression that it was a court order and that I would be punished by law if I did not sign and agree to it.
Do you find that to be incorrect?
I find that to be incorrect because that is in violation of my 14th Amendment to procedural due process, due to the fact that that is an offer. Due to the fact that that's an offer that's voluntary.
Okay. Now you actually have had a contempt citation filed against you, correct?
I have, and I was unable to pay, and that is against the law according to the Department of Justice letter that was mailed out to you guys on March 14, 2016.
Now you actually though, you did serve your 6 months for the contempt, correct?
I did.
Okay. And that was in 2017 and 2018?
Yep.
Okay. Judge, I don't have any more questions for him at this time.
Okay.
I may have some follow-ups in a little bit.
Mr. Gill? I've listened to what I believe I understand what your position is.
Okay.
The court disagrees with it respectfully.
Okay.
I find that through the orders that the court has taken judicial notice of, you were found it is your father of this child that's the subject of this matter, and 10-year-old child, almost a 10-year-old child, and so you're the correct legal father, and you were still ordered to pay $249 per month until the child's emancipated. He's years away from the emancipation. He needs to be you have that legal obligation as the biological or legal father. You're both the biological and the legal father according to these legal documents. And Ms. Pringle, as the custodian of the records and witness in this matter, and despite the document, you presented no proof of payment.
Now,
and these tax refund intercepts are going to help pay on this. It's true. Of course, this is a debt that you owe, and
how, whenever
that it's a legal debt under state.
The piece of personal property is not mine that you guys have to lien against that's causing this debt. That's not my property. How am I responsible for a debt that's not mine that's applied to personal property that I don't own? How is that possible?
Maybe a disagreement.
The only thing that debt is attached to is that Social Security number, and I don't own that Social Security number. And since DHS is saying that I owe a debt, they need to prove that I own that Social Security number. The burden of proof is on them. They're the ones saying that I owe.
In the court's opinion, it's not the debt against the Social Security card, it's the debt against you personally.
It's the debt. Look, you can only apply a debt.
Father of this child.
Okay, listen.
An obligation to help support this child. And so, I find that there's a balance of $362.45.
Well, the burden of
May 20. Does it go through this month?
Through May, yes.
Through May, so that was last month, wasn't it?
Yes.
So, Judge, are you denying that a debt is not a lien that's attached to someone's personal property?
I think a debt judgment, once judgment's entered and you've had some judgments entered against you, that can become a lien against real and personal property. And that's just to help satisfy the debt. I mean, if you got
the only thing that debt is attached to is the Social Security number. That's it. Without that Social Security number, just like on the document that you guys gave me, the debt is next to my Social Security number. That's all you guys have it linked to and attached to. Okay, well then this case is fraud.
If you didn't have a Social Security number,
then you guys wouldn't be able to find me in the system because you guys need the Social Security number to operate the whole child support system. Without that number, you guys can't operate child support services. It's clearly stated in the child support employee handbook. It's clearly stated. I read all the handbook. This is fraud. This is fraud. This is fraud.
Yeah.
Okay.
Well, but sir, is your child a fraud? Do you know?
No, my child is not a fraud. The debt that you guys saying that I owe is a fraud because it is a lien against property that is not mine. And I've repeated myself 5 times about that. Do I need to go over the definition of a lien and what a debt is?
Okay, and Mr. Deal?
Yes, sir?
You know, this court is respectfully disagreed with you. And so I've made my order.
Okay.
And this is one step. You can
appeal it, yes.
For you, and you can file your appeal with the appropriate district court.
Yes.
And you need to do so within 30 days.
Yes, sir.
File a petition in error with the appropriate district court within 30 days.
Yes, sir.
The date that I signed the journal entry now, I don't know if I'll sign it today or tomorrow. Probably sometime this week, I would guess.
And I'm also going to sign forms with the IRS, letting them know about the identity theft and the fraud, and that you guys are illegally stealing my money.
Okay. You have a right to appeal the decision.
Okay.
That's reduce the debt that you owe. You've made other payments over the time, I believe. Is that correct, Ms. Johnson?
Yeah, there's been a few payments made. There's been some, yes.
Yeah, there have been some famous names in the past too. Anyway,
See, and then, to be honest, this court hearing shouldn't have went as far as it did because I separated myself from the legal entity and I separated myself into the natural person that I am, and you still continue to go on with this, and you're only able to interact with another corporation who is the legal entity, who is the name of the obligor that is in all capital names that you have on that paperwork. So I don't understand why we even continue to go through this proceeding if I already done separated myself from the legal entity. You openly admitted to that. You told me okay. But it's okay.
Mr. Dill, are you the legal father of this child? You admitted at some point in time and you've made some payments.
I said that I signed the paternity acknowledgement under duress and coerced because I was under the impression that this was of the state and of court and that I would be punished by law. That is what I was told, and that's why I signed that. Nobody told me that I could deny this and that I have to be responsible for the paternity test cost to the state. And I wouldn't be in the position that I'm in now with child support. Nobody told me that. That is my violation of my 14th Amendment right to procedural due process. Nobody told me the full terms and conditions of the program. Nobody did.
Okay.
It's a fraudulent case.
But you would have had a right to, sir, you would have had a right to appeal back.
That's right, but nobody told me that either, so that's another violation of my 14th procedural due process. Nobody told me that either. Nobody told me that either.
Do you understand you have a right to file a petition in there and appeal to the...
I understand that I can appeal this decision. I understand that I can appeal this decision.
Okay, see, Ms. Johnson, do you have a correct address for Mr.
Yes, I do have a current mailing address. He acknowledged that on the record today, Judge.
Yes. Okay, all right. Is there any, so, to probably get the order, I'll get it within today. It doesn't need to be today. We're all under, President Lake.
Yeah, I have docket tomorrow and Wednesday, so I'll get it to you by the end of the week.
Okay. Now.
And Mr. Dill also needs to understand that's the appealable order. So once from the date that order is entered, his appeal time starts to run.
And what about the fact that Charlotte Stokely is a person of unsound mind and that any contract signed by her is invalid in the state of Oklahoma? And that's the fact that she's on TANF and receives SSI at the same time. You can't have TANF and SSI at the same time.
Okay.
This whole case is fraudulent. I'm trying to point that out to you guys, but that's okay. That's all right.
Okay.
Okay.
Well, all right.
So we're done here?
In order, if you don't have it, now, Mr. Dill, if you don't get this order, say within 10 days, Ms. Johnson, I will say this. If you don't have the order to me Thursday, on Friday, I'll be teleworking, and it will be, I probably would wait until Monday before I...
Okay, you prefer to have it before Friday? Okay.
Well, I give you time to think. I think I could send it, sign it, and get it back to you on Friday, so that would be...
I'll get it to you before that. I know it's kind of tedious to sign all that stuff while you're teleworking.
No,
so I'll get it to you.
I'm just trying to think. I don't have a printer up here, but I don't think I need a printer, because I think you'll just do it like any other order, so
Right.
Friday should be fine, too. I'm on duty this Friday, so it shouldn't be a problem. So if it's June, I don't know what Friday is. It's June 6th, maybe?
I don't know. 4th. I think it's the 4th.
Whatever. So Mr. Dill, the time begins running from the date the judgment center, but it'll take a couple more, it could take 3 or 4 days before you get your order, Mr. Dill.
That's fine.
So anyway, all right. But they are showing payments for you now, Mr. Dill, so that's the other side of the coin, and you can decide what you want to do in that regard. Okay. This concludes this hearing at this time.
All right, thank you.
All right. Mr. Dill, you can disconnect the conversation.